Welcome back, everyone, to the employment space. This channel is designed to provide to you a 360-degree view of the employment relationship directly from an employment attorney. Now, this channel is for employers, employees, independent contractors, vendors, employment attorneys, and HR professionals. Now, we are smack dab. Today, we are smack dab in the middle of the Federal Employment Law series. And we started with the Fair Labor Standards Act, which is a federal employment law that most U.S. employers misunderstand. And then we moved on to what is probably most commonly known as the Workplace Discrimination Federal Employment Law, which is Title VII of the Civil Rights Act of 1964. And let me tell you, Title VII is so foundational to all federal employment laws, and it's also the most litigated. And then we moved on to the Americans with Disabilities Act, the ADA. And you know what? That particular act, it creates probably serious risks for employers due to failure to follow process. And then we moved on to FMLA, the Family and Medical Leave Act. And you know what? FMLA is really not a difficult law. It's just easy to mishandle. And then we moved on to the Age Discrimination Employment Act. The ADEA is the type of federal employment law that you have to beware, especially at specific times of the employment relationship, because it could be easily triggered. And today, we're talking about the Equal Pay Act. Most employers don't think that there's an issue with the Equal Pay Act until there's a compensation audit or threat of litigation. So that's why in this post, I'm bringing you the 5 things employers should know about the Equal Pay Act. Let's get into it. Is exactly where we typically start, and that is, are you a covered employer? And you know what? EPA is similar to the Fair Labor Standards Act. In other words, there's no numerosity requirement as it is with Title VII and the ADA and FMLA and ADEA. In other words, there's not a certain number of employees that your company has to have in order for you to confirm whether or not you're a covered employer. In fact, if you are a U.S. company that has confirmed coverage under the Fair Labor Standards Act, then you are also covered by the Equal Pay Act. It's that simple. So with the EPA, it's not really about coverage, it's about compliance. Moving on to number 2, equal work does not mean identical jobs. This law requires equal pay between men and women who are performing work that is substantially equal in skill set, in effort, in responsibility, and that the actual work performed is being performed in the same or similar work condition. It's not about labels, it's not about job titles, it's not about departments. It's all about the actual work performed. Moving on to number 3, and that is intent. The mere presence of a pay disparity may create liability. Just as we've mentioned under the other federal employment laws in this series, there is no requirement for there to be intent shown by the employer. In other words, it's all about what you can prove. It's all about documentation. It's not about whether you intended to discriminate. It's very simple. If there are opposite sexes performing the same actual work in similar working conditions, then the pay should be comparable. So intent doesn't matter. Number 4, there are very few defenses under the Equal Pay Act, and they must be legitimate. So there are not many defenses under the Equal Pay Act. Factors such as merit systems, a seniority system, or maybe even like a performance metric that highlights the quality or quantity of production typically suffice. It's all about having legitimate reasons that are consistent and well documented. Any reasons leading to pay disparities that go unsupported are definitely going to create risk for the employment relationship. Moving on to number 5, and that is equal pay issues generally arise during times of hiring, promotions, and raises. So think about it. Pay disparities are commonly going to happen during times of hiring, during times of promotions and pay raises. Why? Because during this time of the employment relationship, there's going to be more of an opportunity for there to be one-off conversations between the talent and direct management to talk about things that maybe management didn't know the employee was performing during the year that renders value to the organization. And of course, most oftentimes employers want to reward employees for valuable work performed. So the direct manager can enter the conversation for hiring, pay raise, or promotion, having a set compensation in mind, but during that conversation, learn something new that the result is increased compensation. That results also in incremental disparities. It could result in incremental disparities that are not really properly justified. So you want to be very careful there. It's not that you don't want to have a difference in pay, but it just means that the decision should be centralized and well documented. Okay, so we're going to end here today for the 5 things employers should know about the Equal Pay Act. I hope this was helpful. Again, this channel is designed to provide you a 360-degree view of the employment relationship. Remember to like, share, subscribe. You know, the Equal Pay Act is all about structure, foresight, and documentation. So keep that in mind for compliance. I'll see you next time. Bye.